My name is Amanda Johnston. I'm a partner at Gardner Law, and I practice healthcare compliance and FDA regulatory. Primarily, I lead the compliance and regulatory teams at the firm. And before coming to Gardner Law, I've been there about 6 years. I worked in-house at Medtronic and Coloplast and United Healthcare in various regulatory, legal, and compliance roles. So I have kind of that in-house and now kind of being outside counsel experience. So yeah, and I'll let my esteemed colleague here introduce himself, David.
I'm David Glazer, and I figure we should just dive in, so I'll stick with that.
All right, great. So good. That was a really great segue into kind of what we're going to talk about now. We are going to focus on kind of practical tips and best practices when it comes to improving compliance. Does this thing, let's see. There, perfect. We're going to start with just a quick refresher on compliance program basics. That should not be new to anybody really. And then we're going to talk about the DOJ's recent issuance of their False Claims Act enforcement update that came out last month. And then we'll talk about some trends and themes from that. Then we'll go into some practical tips, best practices, and we'll finish up kind of building on the last session, talking about how to prepare for an unexpected visitor from the government. And then we'll have time for questions as well. So this is kind of where I like to start, training or presentations just to ground everybody, but these are the elements of an effective compliance program. They were initially outlined in 1991 as part of the US sentencing guidelines, and then later adopted into various industries, including the OIG, which have rolled them out for medical device, pharma, and providers. So these are, the core of what a compliance program should embody. We want to have written policies and procedures outlining the compliance rules, leadership and oversight. So a compliance officer, compliance committee, somebody that's responsible for maintaining the compliance program, making sure that there's effective training and education in place for all the staff based on their roles, keeping effective lines of communication open between the compliance officer and the compliance hotline, so that staff know where to go if they have questions or concerns. Enforcing standards and also incorporating consequences and incentives. The DOJ is pushing for working incentives and clawbacks into compensation arrangements with between companies and employees. So that's something that's been coming up more often lately. Risk assessment really should be the umbrella over all of this. But thinking about kind of risk-based approach to your compliance program, and particularly when it comes to auditing and monitoring. And then the 7th is responding to detected offenses promptly, and then actually addressing them. So initiating corrective action and addressing issues that come up. All right, so the DOJ recently issued, so every year they've been keeping track since, I think, 1986 of all of the False Claims Act recoveries that they have received through settlements and judgments. So I'm a nerd. I like to look at this every year and kind of look at the trends and kind of how it's been going. So just wanted to highlight a few. It was really a record year for the DOJ. I think everything increased with the exception of the number of recoveries. So the total settlements and judgments was 2.9 billion. That was up from 2.8 billion, I believe, last year. The number of qui tam lawsuits, highest in history, 979. So that's a trend we'll talk about in a little bit here. Total cases resolved, 558. So that was the second highest. And then also the total settlements and judgments since 1986. So I think that's when they started keeping track, is $78 billion. So you can just see how much of it's a revenue stream for them. So it's interesting to think about kind of as we see shifts in the administration and agencies, like how will this, how will the enforcement priorities shift, if at all? But you can't deny that it is a giant part of their revenue. So here's just a comparison from last year to this year. Everything on the screen went up. I think, like I said, the only thing that did not increase, which stayed pretty flat, was the number of cases, which I don't know what the difference is between the total FCA settlements and judgments and the number of cases is. But so it went up from 2.68 billion to 2.9 billion. Again, the Ketam lawsuits, that's a significant increase from last year. And we've seen that trend continue in the last 5 years. Ketam recoveries. So they're about 82% of the False Claims Act recoveries from last fiscal year were from Ketam suits, so whistleblowers. So that is a primary source of False Claims Act enforcement. And whistleblower payouts were 400 million last fiscal year. So looking at kind of their priorities based on what they've said about last year and the last couple of years, it's not really a surprise. Healthcare fraud is the largest sector. They're continuing to heavily scrutinize many areas of healthcare fraud. The opioid crisis and pharmaceutical fraud is one that we've continued to see. The DOJ continues to aggressively pursue companies and entities that they believe had a role in the opioid crisis. They're targeting drug companies, providers, pharmacies. One case from last year, which I just has a interesting set of facts that I wanted to bring up, was the EndoHealth Solutions. So this was an opioid manufacturer who was trying to get approval from FDA for an additional claim to their product that it was tamper resistant and crush resistant. So they had submitted data to the FDA in a supplement. FDA declined to approve that. But the field went on to actually use a hammer. So they brought their pills and another pill and would like smash them with hammers to show that they were tamper proof. And so that's just an interesting way that they were kind of making that claim that it was shatterproof, it was tamper resistant. And so that is really the fact pattern that drew a lot of scrutiny in that case. So I just think it's an interesting one.
You're saying don't get hammered when you're doing your sales work?
Yeah.
That's what I heard, at least.
I can just imagine some sales reps sitting like with hammers at a doctor's office. I don't know. It's just funny. Yeah, don't get hammered. Medicare Advantage fraud is really increasing. So that's an area to watch. Medicare Advantage is now the largest component of Medicare, both in terms of federal dollars spent and the number of beneficiaries. And sicker beneficiaries, companies will get more money for them. So there's been a rise in kind of unsupported diagnoses. And then either it's unsupported diagnoses or they aren't getting the proper care because their diagnoses are serious, but then there aren't follow-up visits. So there's just been a lot of activity in the Medicare Advantage space lately as well, something to watch. We're continue to see kickbacks, Stark Law violations, and then pandemic relief fraud. We talked a little bit this morning about the PPP stuff. That continues to be an area of focus, and I expect it probably will continue for a couple of years. We've seen, so this last year there were 4 cybersecurity False Claims Act settlements. Actually, the first Ketam lawsuit related to cybersecurity. So this is the DOJ's civil cyber initiative. So that's a growing area to watch, and I think it's going to become a prominent area of enforcement going forward. And then military procurement fraud. So this, again, kind of harkening back to the origins of the False Claims Act. We have some defense contractor fraud actions and enforcement, and then whistleblower incentives and Ketam actions. So the DOJ clearly they want people to raise their hand. They want people to go to the government, and they've put in place quite a few incentives in addition to getting a portion of the recoveries. But yeah, like I said, 82% of the cases from last year were Ketam actions, which is crazy. So that amounts to 18 new cases filed every week. Scary to think about. So just some of the hot themes that we saw in the last couple of years. Again, opioids is still going to be high on the list just because of the visibility. I think we'll continue to see kind of provider, pharmacy, pharma company scrutiny in that area. Lack of medical necessity. So we're seeing cases where claims were submitted to Medicare that lacked medical necessity, unnecessary services. There were a couple cases where patients were being treated for mental health conditions, but then instead of discharging them, as would be kind of typical with that particular condition and the standard of care, they did not. So they were able to continue billing when, they didn't meet the criteria to receive that inpatient care still. And then I mentioned Medicare Advantage. I think we're going to see that particularly with elder care and kind of community health areas. So just something to keep an eye on. Kickbacks, I think this is going to be it's here to stay. We are continuing to see traditional kind of kickback cases, paying doctors more than fair market value, paying them for services that weren't rendered, luxury trips, lavish meals, almost every week, I feel like another settlement comes out, even just in 2025 so far. And we've now seen kind of a resurgence on speaker program focus. There was a recent case, Pfizer just settled for it. Well, it was Biohaven that Pfizer is settled on behalf, but the government is definitely looking at speaker programs still. So something to look at. I was at the Pharma Compliance Congress this fall, and Mary Reardon from the OIG was there, and she had reiterated that there would be more speaker program settlements coming. So she made it sound like there would be several. So I imagine this is probably the first of a few.
So, man, I'm going to chime in just real fast on that one, which is, it's interesting. If I had to pick, would I rather defend a program that has 500 physicians paid a small amount of money, or 4 physicians paid a huge amount of money? I would definitely prefer to defend the latter. And my thinking is, if your program is designed to encourage kickbacks by paying doctors, you can't make the money off of 4 doctors, right? The referrals from 4 doctors aren't going to do it. So even though those doctors are making a lot of money and it make it sound worse because their take home is bigger, I think it's much easier to defend, because if you're trying to come up with a scheme, you'd want a lot of doctors in it. And so I have a strong preference for using physicians, the same people, a lot, and keeping the pool small. So that's my
interesting. Yeah, no, that's an interesting point. Because I think in the Pfizer case, it was mostly in the lower tens of thousands, but then there were a couple that were up higher. So yeah, it's a good point. So just lessons, kind of takeaways. The theme, whistleblower risk, is really at an all-time high. Now's the time to kind of look at your internal reporting mechanisms, remind staff of, we really want you to report concerns to us before you go to the government. The idea is that you guys are detecting fraud before the whistleblower does. And I wanted to bring up, there's kind of a nuance in one of the self-disclosure programs, that there's this 120-day rule. I don't know if anyone is familiar with this, but I wanted to bring it up because I think it's just odd. So whistleblowers, if they report internally through their compliance hotline, and then report to the DOJ within 120 days, they essentially are eligible for an increased award. So they're trying to incentivize whistleblowers to first report internally and then report to the government. But then they also go so far as to say, if the company receives an internal report and then self-discloses that within 120 days, the company is then eligible for that disclosure program. So they're almost creating like a race to report. So, I mean, I guess, if you do get a report, investigate it quickly and try to figure out if it's something that would rise to the level of something that you would want to self-disclose, because you have that 120-day window. I think that's an interesting nuance. But it'll be interesting to see how that plays out, if it does play out. But yeah, essentially creating kind of a race to report. Healthcare enforcement is not slowing down. It's the majority of False Claims Act. So, it's not a time to sit back. Cybersecurity compliance is something that companies should be looking at, especially if they're contracting with the government or have even contracts through, if, you know, say you have a software and you're licensing it to a governmental agency or working with a governmental agency, keeping that in mind. And then just continuing to expect continued aggressive enforcement against improper billing, kickbacks, unnecessary services, kind of the garden variety fraud. So how to adapt your compliance program? Really the whistleblower piece, I mean, continuing to reiterate the compliance culture tone from the top. Conducting a risk assessment, if you haven't done one in a while, is a good idea. Again, the risk assessment should drive your entire compliance program. So it should be based on the risks that are specific to your company, based on where, you know, what industry you're in and what your business practices are. So making sure that you are looking at those specific areas and kind of think back to that hot topic slide. Those are the ones that I would start with, but I would also then kind of really review all of your business practices and identify risk areas, and then use that information to review your policies, review your training, making sure that you are addressing and correcting issues quickly if you find them or if you identify them. Holding leadership accountable, it's a big one. It's a challenge. It's easy to say that, but just making sure that you have, and I like the discussion in the last session about emails and writing it right. It really is so important. And I think that trickles down into the organization. I mean, it does. So just tone at the top is really important in making sure that compliance is front of mind. And then keeping an eye on enforcement trends. So, I mean, I feel like every day this last month, there's been, my email box is blown up with different updates and things that are happening in the government. But just keeping tabs on that is really, really key, because then you can be nimble and make adjustments as you need to, or as you, as priorities shift and enforcement trends change. And just in closing, kind of, again, going back to the whistleblower self-disclosure piece, is honesty the best policy? So just thinking about, and again, there's not a right or wrong answer here. It's going to be dependent on the situation. Again, think of that 120-day rule. So if you're the company, you don't know necessarily if the whistleblower is going to go to the government, but still having that timeline in mind and thinking through like, okay, is this something that we would want to disclose? And then risks and benefits of that. Some risks of disclosing. DOJ could expand into other areas. They could start asking questions, and trying to keep them kind of reined in it will be a challenge. Once you disclose, you can't go back. There's no guarantee that you're going to receive a presumption of a declination to prosecute or anything really. And there's a risk of them finding additional issues that you didn't anticipate or didn't know about. But if you don't disclose and they discover it after the fact, or the whistleblower goes, you know, and you don't know that, and within 120 days, they go and report it, you could be worse off. So penalties could be more severe. You wouldn't get that cooperation credit necessarily. So yeah, it's an interesting dilemma to consider, and there's pros and cons on both sides. All right, and that's all I have I'm going to hand it over to David.
So I'm going to talk a little bit about kind of cultural things and the like. And my goal is to leave a few concrete points. So we've started a little late, so we will end at 10:35, whether we're done or not. And so, you know, in America, there's a lot of talk right now that there are culture wars. That's also true in compliance. And so I'm going to start with it. This is a bit of a question. I'm going to make the people in the room raise your hand. Those of you who are online get to kind of ignore that part. But so do you think compliance is, and I'll go through all four and then show you, is it doing what's right? Is it doing what the government says, which apparently this isn't going to work. So let's try this. There we go.
Oh, that one.
We went. Okay. Is only your computer working?
Yeah. Which one do you want me to do? Yep.
Okay, apparently you can't back up very easily. There we go. Well, that worked really well. So is it doing what the government said, right? which that to me is that's my quintessential, the government said. Is it doing what's legal, or is it doing something I hadn't thought of? So is it doing what's right? If put your hand up if you think it's doing what's right. Okay, couple of hands. That is, so if I give this talk at the Healthcare Compliance Association, that's what most people put their hand up at. Okay, so, and part of what I'm getting at here is when you're working with compliance and legal, there's a cultural gap in how you get past that. Because at the end, I think we all have to speak the same language. Is it doing what the government says? And I see some nods here. Couple, so I'm just, I'm going to go that we're 7% on each of those two. And how about doing what's legal? All right, that's the majority. And I think for lawyers, that's what I would hope to see. Doing something I haven't thought of. Is there some other option I've missed? Okay, what did I miss? All of the above.
Yes.
The old all of the above answer.
Yes.
So here's what when people say it's doing what's right, I immediately say, okay, I've got money. And this, for those of you who don't bill, this isn't the best example, but for those of you who bill, I've got an overpayment that I want to refund. How far back do I go? Using the what's right test, how am I going to answer that question? And I think the answer is I can't, right? We are in a regulated environment. And so doing what's right isn't, I mean, it may sound good, but that is not. The FDA, there isn't an ethics thing here, is what the FDA says and what the FDA doesn't say. So I think I'm staunchly in the doing what's legal camp. And as for doing what the government says, I would say if that were the case, we don't need lawyers. We wouldn't have jury trials. What the government says would go, right? So, thank you. You got to remember that I can't use my computer. All right. So real world problem. Someone walks in, and this sounds like the setup for a joke, but I heard that's illegal is what the person says. And your job is to figure out, or the job of your compliance person, are they right? In which case you need to take that seriously, or do you need to talk them down like they're wrong and you need to explain to them why they're wrong? And so I am a lawyer. I am very much not a psychologist, although I am married to one. This is an area where I think law and psychology merge. And a huge part of this is getting everyone on the same page again. Now, often in life, there's a Billy Joel song for things, right? So this could be, Alex is looking, you're like, I'm crazy, but it's a matter of trust. Oh, so you don't like Billy Joel? Fine. It's a matter of trust, angry young man, keeping the faith. I could just go on with Billy Joel songs, right? So if someone comes in, you've got to figure out if they're credible or not. And one of the big things is listening with an open mind. But one problem is I think there are often what you might refer to as frequent flyers in the compliance world. They're the people who cry wolf, and you wind up with the, wait a minute, isn't anyone here a real sheep problem? And I would posit that if you've got someone who is a frequent complainer such that you are no longer listening to them, one of two things must happen. Either you need to readjust your outlook so you are capable of hearing them, or you need to part ways with this individual. And the reason for that is what I call the stopped clock axiom, which is even a stopped clock is right twice a day. And so the person might have complained 30 times before and been wrong 30 times, but if they're right on the 31st and you don't listen to them, it isn't going to end well. And so you either have to keep listening or have them gone so they can't complain anymore. And that, I mean, firing a whistleblower has all kinds of employment issues, I know. Yeah. But frankly, it is better than not listening to them anymore, right? Like, yeah. If you're choosing between them, that I think is the better poison. Now, I mangle this quote all of the time. I think it's Indiana Jones in The Last Crusade. And it's, you must choose wisely, for one grail brings you, the true grail brings you life, whereas the other takes it. Something like that. There's a lot of choosing wisely that happens here. And one thing I'm going to skip ahead of for a moment, which is how much thought do you think about how you interview people for your compliance team? I think it's one of the most important things you do, and what questions you ask will matter. So I remember once interviewing for nannies for our house, and you're thinking, what does that have to do with anything? Well, it'll show up here. Have you ever been in the big house? I asked. And the person was like, oh, well, yeah. And you start getting answers to this, right? You should be asking people at your compliance process, hey, what's a time you disagreed with your boss? What did you disagree about? How did you handle it? What happened? How did you decide if you were right or your boss was right? Because a lot of compliance are situations where someone thinks something is illegal and you want to figure out, will they listen to you if you try to talk them off the ledge? And will they bring it to you, or will they go be a whistleblower, right? Which approach are they going to use? And you can learn a lot of that if you ask, but it makes the interviewing thing really important. Then another thing you can do, it's The Power of Coffee, which has me thinking Huey Lewis, The Power of Love, different song. I had a compliance officer once who took all of her people out for coffee on a regular basis. And the benefit of that became clear when someone was really mad at the organization and they went to her because they trusted her. And so I think there's a lot to be said about being approachable. And some of that is like telling stupid dad jokes like I did, right? You want people to feel like they can come to you with the problems. Then Name That Whistleblower, which would be a great game show. So I, at one point, had been through 30 cases where there was an FCA case with a whistleblower. And, you know, like everyone, we were trying to identify the whistleblower. I had managed, or my client had managed to come up with them for the first 30, 0 times. I'm now at 2. I've identified 2 correctly since then. It is a terrible game to play for 2 reasons. First, my 0 for 30 demonstrates, I mean, I might just be bad at it, but you're not going to figure it out. But second, the process of trying to figure out who the whistleblower is sends a message to people in the organization, which is that you care, like you're trying to root it out. And ultimately, you don't want people to feel like who called an issue is what matters. It's the issue that matters. And so I really think that the game of Name That Whistleblower is counterproductive, and I don't think it's good to engage in it. So next we've got aha, which is you don't want the person to feel, which is take on me, right? That was okay. So I only lived music in the 80s. So when someone comes in, I often wonder, is it better to engage them right then and say, I think you're wrong, or is it better to take it under advisement? And I increasingly think it is better to take things under advisement because the person feels listened to. And like I did a webinar, we have our monthly webinar, and yesterday I got something wrong. The 60-day rule had changed and I missed it. And I learned that by going back afterwards and, you know, kind of realizing I'd goofed. And that can happen. And so I'm a big fan of taking things under it. And then I also want to ask people for citations to authority. And of course, citations to authority would be abbreviated CTA, which is the Chicago Transit Authority. And that's because it is hard to say I'm sorry. All right. That was 2 80s songs on one slide. But if someone comes in and says, we think you're doing it wrong, they're in the best position to say, what rule are they relying on, right? And they may have one, they may not. They may just be in it's immoral camp, right? You're doing the wrong thing, which is different from the legal thing. Then the legal hierarchy, everything on this slide is binding. So the Constitution, statutes, regulations, national coverage decisions, those are all binding. Everything on this slide is not. And one of the things that's really big on there is LCDs. Local coverage determinations are not binding. They feel binding. And actually and you might choose to follow them. And this highlights one of the next really practical problems. You want to establish a policy that is a risk management more protective than the rule. How do you do that in a way that you don't that you're not making life easy for the government? And I think this is really hard. I am a big fan of candor. I will say things like, the rule does not require this, but as a matter of corporate policy, we expect X. Just being very direct. I don't like saying it's required compliance people sometimes will want to use exaggerations of the law because they're afraid no one will take them seriously if they just set it up as a matter of policy. And what I say, if I started swearing here right now, I wouldn't be breaking a law. And Frederickson could totally fire me. I could say fire my ass and make the swearing thing really work, right? They could totally do that. And there are all kinds of times the company can act without a legal basis. That's fine. Don't pretend there's a legal basis because then it lets the government come in and hoist you on your own petard. And how do I know this? I'm not going to talk about this because we don't have a lot of time, but there's a statute that says if something isn't this is only for Medicare, but if something isn't a statute or a regulation, it's not binding. And like as for manuals, I lost a case once where my client had relied on something in the manuals, and the Court of Appeals said, you rely on the manuals at your own peril. How do we know LCDs aren't binding? Because there was a case out of Alabama, the AseraCare case, which happened to be a hospice, but that doesn't matter. So the hospice had a policy, or there was an LCD related to what constitutes a terminal illness. And the hospice wasn't following it. And we went up to the 11th Circuit, who said LCDs are eligibility guidelines. They're not binding, and they're not the exact criteria that are used. That case actually sat at the 11th Circuit for like 2 years. And it's a big deal because it's a court decision that says that LCDs aren't binding. So I've got this cabin up north, and I spend a lot of time trying to figure out what things are. So the foot on the left is mine. I don't know the foot on the right. I'm really curious. If you're a good footprint identifier, we have a pet bobcat. It might be that. It might be a fox. I don't know. You're often trying to figure out what something is. So what do? You Google, right? Okay, Googling's a great idea. This is a regulation that won't apply to most of you guys, but there's a diagnostic test regulation. And I Googled it, and you got to have really good eyes. But look in the upper right corner. If you look in the upper right corner, you will see that this is from 10-1. Oh, this is the first hit, by the way, if you Google it. I knew the regulation site, so I just Googled the site, went to the first hit, which happens to be from 2003. So if you put that in perspective, that regulation is old enough to drive, right? Actually, it can vote. This regulation can vote. It is also not accurate. And so there are just a few other examples. It's how to look at stuff. When you Google, I'm not anti-Google. I notice it's gotten worse. I think the ability to find actual information that is right through Google is deteriorated. But you got to be careful. You have to look at the stuff at the bottom. Look at the date, right? It'll tell you, hey, when was this last updated? And I stuck here links to, if you're doing research online, these are what I use, and you want your team to use them, because if your folks are Googling outdated versions of the rules, they're not going to help. I'm going to skip what's going to get you on. I'm going to skip those two. This is going to kill me. I'll even skip that cartoon. We're going to end with, here comes trouble, right? And I have to apologize to my daughter, Zoe, every time I use this slide because it has a shark, and the shark represents the government, which is kind of coming to get you. And as she would say, sharks are good, so I shouldn't use the shark as a, but I don't think government agents are bad. I just think it's a little scary when they come after you, just like a shark. So when you came in, you may have seen one of these, what you need to know if you're contacted by a government agent card. You're welcome to steal them. You're welcome to steal them in two senses. If you want to use one of those in your organization, by all means, just it's not proprietary. You can take the information, throw it on your stuff with your in-house contact information. So any of the agencies on here can show up. Some are obvious. I think everyone in here knows that the Office of Inspector General is the OIG, and everyone's heard of the FBI, right? You watch TV. Mafuku, the Medicaid Fraud Control Unit, which sounds like I'm swearing on stage, is out there a lot. Postal inspectors, and you may say, what does postal inspectors have to do with anything? But if it goes through the mail or wire, it's wire fraud, and they can investigate. In fact, if you have a big investigation, the odds are someone from the Defense Criminal Investigative Service or postal inspector or the like will show up. They work often in concert with the FBI or someone like that. So you might see the Defense Criminal Investigative Service on a thing, and you're wondering why, right? So I'm a slow learner. You need your folks to understand that someone might show up, and you need to know ahead of time, because when they show up, agents have this habit of saying things like, I would appreciate it if you didn't tell anyone I was here. And when someone with a gun tells you they would appreciate something, most people will listen to it. And so they need to know ahead of time what their rights are. And even then, they will forget, because it's scary when someone with a gun shows up at your door. But you increase your odds if you tell them, and probably the most important thing is, if someone shows up at your door, you have the absolute right to tell us. And we know that because the only government contacts someone can't talk about are terrorism investigations and a few very limited banking investigations. Those aren't the kinds of things you're likely to run into. So I think you can say safely, if someone claiming to be from the government shows up, you can tell us. And I emphasize the claiming because the number of times I've had someone claim to be from the government but not is dramatically increasing. More in the provider world than on the device side of things or in the drug side of things. But like doctors will get phone calls from someone claiming that their prescription pad was found in a car and that they are a part of an opioid investigation and it's all a scam. And that sort of stuff happens. So and they might get a call that shows up as it's from the FBI on caller ID because the number is spoofed. If you get a letter, letters are easier because you don't have a rush, right? So you figure out who sent it, you get a copy of everything you send. Letters, everyone can work through counsel. What I'm more worried about are phone calls. And if someone calls, you get their name, you get the name of the agency they're from. It's kind of like a call from a reporter. Who are you? What's your deadline? You'd ask a reporter, what are you calling about? This is the important point. Now, just a minute here. How are we supposed to know you're the real angel of death? You need to verify anyone who's on the phone. I would assume, until you know otherwise, that anyone who's calling isn't real. I would be super polite. I would say, hey, I just need to authenticate who you are. Give me your name and your agency. You can ask for their number, but that's not the number you're going to call, because if they're fake, they just, everyone who watched Seinfeld knows Vandelay Industries, right? George would say he worked for Vandelay Industries. He would give Jerry's number. That's a thing that happens. So you look them up on the internet and you call them back.
No, so just added a slide on FDA because I know we're focusing solely on FDA or primarily on FDA. If an investigator shows up, first thing you do, ask for identification. They should have a Form 482. That's a notice of inspection form that they should present to you. It will outline what they're looking for, if it's routine, if it's focused. Don't panic. Notify the internal FDA response team. So again, something to have in place beforehand. Have a phone tree. Identify who's going to be kind of on call for that type of scenario. Ask questions about the scope, and then making sure that you're escorting the investigator everywhere. You're not letting them wander around. Find a private meeting area. A lot of companies like to do the front room, back room, which I think is a great idea. And then I'll borrow Tim Phillips. He's at Gardner Law. He's a former 35 years at FDA compliance officer. TLAST, tell the truth, listen to the question, answer the question, stop talking, tell the truth. So that's the FDA kind of quick rundown on if FDA shows up.
And the FDA is very different because there you've got a kind of a duty to cooperate that if it's an OIG or FBI agent, I'm going to get rid of the TLAST and go with just sit there quietly,
yes,
right?
Stop.
So totally different analysis because of the regulatory difference, right? So this was a real world subpoena that one of our surgeon clients got. I'm hoping that this wouldn't happen again because the U.S. Attorney's Office that sent this out kind of got in trouble. But the subpoena said, we request you don't disclose the existence of this subpoena. Any such disclosure would impede the investigation. And this is kind of what I was getting at before on they tell people not to talk. If someone reads that, will they tell you that they got the thing? And the only shot you have is if you've inoculated them ahead of time very directly with, even if the government tells you that you can't talk to me, you still can. That actually, to me, should be a part of your compliance training. Okay, very quickly, because I want to leave 5 minutes for questions. If someone has a warrant, they get to come in, right? And the FDA gets to come in. If they don't have a warrant, they don't get to come in right away. And it's rare. It is very rare for people to show up with a warrant. Much more common for them to show up with, maybe they're dropping off a subpoena. Medicare entitles the government to immediate access to records. And so you might think, I need to let them in. Immediate access is 24 hours. So there is no situation absent a search warrant or the FDA, where they come in right this second, get their ID, and then they will often do they will take the beware of dog sign and say, this isn't a big deal. No one ever shows up at your office if it's not a big deal. They've got better fish to fry. People who often they feel confident or they're scared, and either one can get people talking. And they can say things like, oh, my lawyer said this was okay. That statement is a waiver of attorney-client privilege, right? So it is really my goal to get people to not talk. Then the agent often does, and people are worried, well, if we don't cooperate, aren't we going to get in more trouble? And I think this cartoon captures it so well. So the agent is the shark. I'm picking on sharks again. Okay, I'll go back and tell my people you're staying in the boat, but I warn you, they're not going to like it. Well, they're not. You can have happy sharks and talk, i.e. jump in the water, or have mad sharks and stay in the boat. The choice is yours. The agents can't make anyone attend an interview. They can't get documents without a warrant or a subpoena. They can't get privileged information. And as we've said, they can't keep people from talking. A company can't prevent its employees from talking to the government. So we can't say, I can't as a lawyer say, don't talk to the government. I can say, hey, you have the right to talk to the government. You have the right not to. I think it's wise not to, but the choice is yours. I think the point Amanda was making about tell the truth being in there twice is really important because Section 1001, which is lying to a government agent, there are way more lying to a government agent convictions than there are kickback violation convictions. And then don't destroy or hide documents. The good news is most agents are smarter than this. Which monster did this? Godzilla, Gargantua, who? If only there were a clue. All right, we got some questions. Let's see, I see a few here. All right, those are not questions for us. Did you see any on this?
I don't.
All right, if you got in the room, so we've got 1.5 minutes or something before we give you, we go to a break afterwards, and so you can always buttonhole us.
Yeah.
But questions either online or here? No, they're
Difference between responses to the FDA when it's an investigation versus an inspection. So an investigation, they're coming because they have information about something. An inspection is, well, you're on the list and I'm coming in.
Amanda, I'm going to repeat it just for the people online, and then you're going to answer it because you're the FDA person. So the difference between an inspection and what was the other?
Investigation.
An investigation.
There's not really. So those words are used interchangeably, and I know Tim would correct me because I think it's investigator is the name of the person that shows up, and it is an inspection. So, I mean, yes, there's probably a difference if they're coming in looking for something fraudulent, and then they'd probably have the OIG with them. But if an FDA investigator shows up to conduct an inspection, that's like either the routine one or they're looking for something like, after approval, or if there's an issue that has been cited. So those phrases are used interchangeably, but it's an inspection typically. I guess if it's what? Yes. So that's the notice of inspection, the 482.
Right now, I've always treated them different. So
I mean, I guess if they
In terms of
show
what I
up
have-
with,
what I tell
guns.
people to say to the FDA, if it's an inspection with 482, then the inspection rules apply and they have a right to inspect me. But if it's an investigation of some specific thing, they don't get to wander around. It's that thing and you have to find out what they're investigating.
yeah. I mean, I suppose if they show up with the
Now,
FBI or the
warrants, they
OIG,
never step up, right?
yeah, exactly.
All right, I see there's a question mark for the online folks where people here, are you going to get the slides afterwards? And the answer is yes. So, all right, I think there's a break. We'll be back here at 1:45, or I won't, but others will.